Welcome back, everybody, to Contract Law. In this lesson, what we're going to be doing is talking about the idea of contractual intent. The idea here relating to making a lot of delineations between an offer to contract, an offer to form an agreement within a contractual relationship, and delineating that concept with a number of other things that could exist, that could actually be the case. So things like an invitation to treat. This lesson is going to continuing to talk about the first major requirement within the formation of contracts, this being the idea of an agreement, and talking about the first major component of an agreement, i.e. the offer itself, the concept of the offer. Now, we'll explore the requirements which are necessary to establish an offer, in addition to this idea that there has to be an intent to make an offer to contract with the other parties. So we know already that when we are looking at the first component of a contract, we remember firstly that the components of a contract include an agreement, include consideration, and they include an intention to create legal relations, and some of them include a specific formality. The concept of agreement, the first of the major conceptions of, or at least the major requirements of a contract, is split into two. The agreement can be represented as a delineation between the offer and the acceptance of an offer. Now, in identifying whether or not a contract exists between the various parties, finding a clear offer is something which is important. And when it comes to how the courts have approached this question, they have looked at a number of factors to try and make the determination on a more objective standard by which there can or cannot exist an offer in a particular factual context. So arguably, the most important of this is whether there exists a certain degree of what is described as contractual intent. Was there an intent by the parties in question to enter into a contract? And so if that was the case, then the person who is making what is alleged to be the offer has to have the intent to make a contract. So often, the idea of contractual intent is difficult to determine. And for the most part, the importance that we have to think about is how the courts are able to distinguish between an offer, which does have legally binding implications if accepted and the other requirements for a contract are present, and an invitation to treat, which is a completely different thing that is almost like an invitation to the potential negotiations which could give rise to a contract and not actually having any kind of contractual binding obligations in and of themselves. So again, an offer in this context involves the offer to enter into a contract. It doesn't require or it doesn't involve an offer to enter into negotiations, which could give rise to a contract. A contract is legally binding, and so when we think what an offer is, it is an offer to enter into a contract. And so to find a valid offer, the court must be satisfied that there has actually been an intention on the part of everybody who is involved to enter into legal relations. So what is the approach that is issued by the courts in this regard? Well, the answer is an objective standard. The objective standard is the standard by which we try to make this determination. For the most part, the courts have believed that the identification of contractual intent should not depend specifically on the subjective intent of the parties, but rather the objective standard by which you can view the actions of the parties as being or potentially not being an offer. So it should depend on a certain objective standard to make a determination whether or not intent can be found, can be determined. And there are a number of examples and cases where this has been illustrated. The case of Storer and Manchester City Council, for example, from 1974, is essentially a case which hinges on this question about whether or not there was an offer made. Don't forget that this is an important thing to consider, because if there was an offer, and then by extension, assuming that there is the fulfillment of the other elements of a contract, there is therefore legally binding obligations, it means that the people who are involved in this particular dispute are now legally bound to perform the contract in a particular way, or suffer the consequences for breach of contract. So the question of whether or not a contract exists between the parties is one which is often tested and applied by the courts, and has been historically since the beginnings and the formations of contract law. The facts of this case are relatively simple. So we have Manchester City Council, who had made the decision to not proceed with the sale of a council property. Now, this was the case despite there being an agreement made with the claimant under an established arrangement with its predecessor. And so the claimants argued that the contract had been concluded, and then as a result of that, the Manchester City Council could not just simply refuse and renege on that decision, because there is a contract, there is a legal obligation now automatically placed to perform the contract in a particular way. And so as a result of this, they couldn't just simply change their mind and not proceed with the sale of a council flat property. They wanted to see essentially the specific performance of the contractual arrangement. Now, the question here, of course, and the dispute that is arising is whether or not, okay, there actually was a contract. The claimants are arguing that there was a contract, and so as such, the Manchester City Council would have to perform the contract, their terms within a contractual arrangement. The Manchester City Council, on the other hand, argued that no, there was not a legally binding contract, there was not an offer made, and so as a result of this, their decision to not proceed with the sale of the council property is not one that has wrapped up with it any legally binding obligations. The Court of Appeal, however, would disagree with the Manchester City Council, holding there was indeed a contract, and they made a distinction here between an agreement and the idea of an invitation to treat. They said that in contracts, you do not look to the actual intent of the man's mind, you look at what he said and did. A contract is formed when there is, to all outward appearances, a contract. A man cannot get out of a contract by saying, I did not intend to contract, if by his words he has done so. So this is the reason why we are applying an objective standard here, because if you were to apply something of a subjective standard, then this idea of contractual intent becomes something that is a question that is applied to the specific cases of a factual matter. And so a claimant or a defendant in a case could make the argument that they did not intend to contract, and so as a result of which you may be able to get out of their contractual obligations, rather than looking at what the individual themselves actually intended. The concept of determining contractual intent is looking at the outward appearances of their actions and their words, rather than their so-called internal intent, what they actually believed. So this is the objective standard that is applied, and when we think about objective standards, one of the things that we always will hark back to within English law, whether or not we are doing the law of tort, or whether we are doing criminal law, or whether we are doing contract law, is this idea of the reasonable person standard. So in an effort to essentially ensure that there's a certain degree of consistency when applying these objective standards, the court applies what is known as a reasonable person test to an objective standard. Essentially, what the court is doing in these regards is saying, well, when we look at the actions of the parties making a contract or allegedly making a contract, the question that is asked is whether or not a reasonable person would look at the parties and their actions and their words and come to the same conclusion as to whether or not there was a contract. So if you see the words and the conversations of the people who are involved in this alleged contract, and you see the actions of them, and if you were a reasonable person, you would come to the conclusion that they were looking to form a contract, then that is the standard by which we objectively view where contractual intent arises. So, for example, in the case of First Energy and Hungarian International Banks Limited from 1993, we have a case involving a senior manager of a bank who was arranging the financial matters for the particular defendant. Now, the question here was whether or not this manager had the authority to make an agreement which was contractually binding. And ultimately, it was held that the contract was binding, owing to the fact that the manager had what is known as ostensible authority. It says here that a theme that runs through our law of contract is that the reasonable expectations of honest men must be protected. It is not a rule or principle of law, it is the objective which has been and still is the principal moulding force of our law of contract. The court must take into account surrounding circumstances which reasonable persons in the positions of the parties would have had in mind.